Hello everyone. Thank you for being here today. My name is Rachel Moss. I'm a criminal defense attorney at the Attorneys for Freedom Law Firm. We're a law firm out in Chandler, so not too far from here. We also run the Attorneys on Retainer program. Today I wanted to start out by giving you a scenario. So just imagine that you are walking home to your car at night. It's nighttime, you are with your family. Imagine your son just was a part of the local Christmas pageant that night. On the way to your car, you get stopped by another family and you get talking with the parents. As you're talking to the parents, your son continues on to the car. And on his way to the car, the local bully stops your son. And they start to kind of argue back and forth. You don't really notice, you're caught up in a conversation. But eventually they start yelling back and forth at one another. It starts to catch your eye. You turn to look and you notice the argument. As they continue to argue, the bully starts to punch your son. Now you've really noticed. You start to run over to where your son is. And as you get towards your son, the bully pulls out a knife and starts to swing it towards your son. At this time, you are carrying a firearm. It's on your person. You know how to use it. What would you do in this scenario? I think a lot of us know how we would react in that scenario, but we may not know how we would react if that was someone other than your son. Imagine if that person was a friend. Imagine if that person was a stranger. Imagine if that person that was being attacked was someone you didn't really like that much. Imagine if that was you. We all know that a firearm is a tool for self-defense, but sometimes we have not thought through what scenarios we might use it in. Today, I want to talk a little bit about Arizona's self-defense laws, as well as our defense of others laws, crime prevention laws, going into things like castle doctrine. And then I want to move on and talk a little bit about preparedness, when we might think through what times we will use self-defense, what times we would act in defense of others, how we go through that analysis. And then we can talk about how we might handle an emergency situation after it arises. So to start out with Arizona's self-defense laws, there are a few very basic things to know about self-defense. So self-defense is codified in a few different laws in Arizona. First, we have a self-defense law that covers ordinary physical force. So this would be in ARS 13404. Basically what this says is that a person is justified in using self-defense in either exercising, threatening, or using physical force against another person when and to the extent a reasonable person would believe that physical force is immediately necessary to protect themselves from another's use or attempted use of unlawful physical force. So there are a few things to break down there, and some of it's common sense, but I always like to go over it in detail. The first thing to kind of notice about what self-defense statute says is that you're justified in doing something. So self-defense is what's known as a justification defense under the law. Justification is where you take something that would normally be illegal, so something that would normally be a crime, but we're justifying it. We're recognizing that there's certain circumstances where you'd be justifying doing something that would normally be illegal. So for example, I think we could all agree that if we walked outside with our gun, picked out a random person in the street and shot them, I think we could all agree that's a crime. That's something illegal, to shoot another person. However, when there's a circumstance where they're putting your life in danger with physical force, that is a circumstance where something that would normally be a crime, shooting someone else, is now justified. So there's a few other types of justification defenses under the law. There's self-defense, there's defense of others, but there's also something like necessity. The way I put this, a necessity defense is something like normally stealing a car is illegal. But if you're being chased and your life is in danger, you might be able to be justified in stealing that car to escape and to save your life. So just like a necessity defense is a justification defense, self-defense is also a justification defense. Another thing to keep in mind about the self-defense statute in Arizona is we're not just protected when we actually use force against someone else. We're protected if we threaten physical force. So there are some times you might be in a situation where you don't feel like you actually have to use your firearm. Or maybe you're carrying a knife. You don't actually have to exercise the force, but you feel like just pulling it out, maybe pointing the firearm, maybe pointing the knife at someone, or even raising your fist and saying, hey, I'm gonna get you. Maybe in those situations, you might find a situation where you choose to use that threat rather than actually exercising that physical force. Arizona's self-defense law also covers those threats. And why that's important is because you can be charged with crimes just for threatening to use force against someone else. So for example, aggravated assault, a very serious crime in Arizona, is something that can be charged just by pointing a gun. You don't actually have to shoot and injure someone to be charged with aggravated assault. It's enough just to point a gun at someone else. In the same way, if you yell at someone and say, hey, I'm gonna get you, or I'm gonna attack you, or I'm gonna hurt you, that's something that can be charged as threatening and intimidating. That's a misdemeanor offense in Arizona. So threatening is an important part of the self-defense statute. So if there's a situation where you need to threaten to use force, you can still assert self-defense as a justification defense in Arizona. One of the most important things to talk about in a self-defense statute is the reasonableness element, because self-defense always has to be reasonable. And if you are ever charged with a criminal offense related to a self-defense incident, that is really what the jury is going to dive into and consider. They're going to consider whether or not your act of self-defense was reasonable. So the jury gets to consider all the facts and circumstances if a case goes to trial. But there are certain things that rules that are always going to apply when they assess reasonableness. For example, they have to assess imminency. So imminency, you're only able to use self-defense if you're facing an imminent threat. So the example I like to give to this is if someone came up to us today, right here, and said, hey, I'm gonna come attack you on Christmas Day. That's a few weeks away from now. So if someone tells you that, you're not able to pull out your gun at that point and use self-defense against that threat. There's things you can do to prepare for that, but you're not able to use self-defense at that time. But there's a point in time where imminency becomes a little bit more blurry and it becomes something we really have to argue for a jury. The example I gave is pretty obvious. Okay, yeah, you can't use the self-defense for a threat that's 3-5 weeks away. But let's say someone says, hey, I'm going to attack you in 10 seconds. Suddenly it's a little more of an issue that we would have to argue for the jury. I think it's something that if you were to use self-defense when someone said, I'm going to attack you in 10 seconds, that's a case that I feel pretty confident about winning in court, because you don't have to wait for the moment that someone actually starts to attack to exercise self-defense. If someone's clearly threatened you and you know they're getting ready to attack, you're able to act in self-defense. But there's always going to be a level where the prosecutor and the defense might disagree on what was reasonable or what was imminent in that situation. So that's why it's really good to be prepared and think through what sorts of situations you would exercise self-defense in. There's also different rules for deadly physical force, which we'll get into in a second. So ordinary physical force is a little bit different than deadly physical force. So deadly physical force is any type of force that would cause death or serious physical injury to a person. And so this is where we get into the fact that self-defense has to be proportionate. So for example, if someone came at you with a pillow and was just going to hit you with a light pillow and you knew it was a pillow, that's not a situation where you can pull out a gun in response to defend yourself against that pillow, because that pillow is not capable of inflicting serious physical harm or death upon you. Again, there's a situation where it can get a little bit more blurry, where the prosecutor might argue one thing and defense might argue another. An example is, let's say someone was coming at you with just their fist, but they're a really tall, maybe 6'5", really big guy that you think would be capable of knocking you out. That's serious physical injury. But you can see a situation where a prosecutor might argue, hey, this guy didn't have a weapon, he was only coming at him with his fist. That's not deadly physical force. So that's why as a self-defense attorneys, we jump in and say, no, that 6'5" guy that's hundreds of pounds, he is able to inflict serious physical injury or death onto someone with just his fist. But then there's cases where it's much more clear that deadly physical force is being used. Situations with a knife or a firearm. that's where it's much more obvious, and it's easier to tell when force is proportionate. So you always have to consider proportionality when using self-defense. And the jury gets to consider all of these things: the reasonableness of your actions, whether or not there was an imminent threat against your life, whether or not you act proportionally. So they get to decide what's reasonable in a case. And something to keep in mind is that if you are ever charged with something and related to self-defense, you have no idea who's going to be on your jury. You hope it's people that are really gun friendly, but there's never a guarantee for that. And I always say these things not to discourage someone from using self-defense, but just so that you can be prepared that if you are in a situation where you do have to use self-defense, you know what could come after. You know that there's the possibility that you could get a jury of people that are similar to us, that are very gun friendly, that maybe grew up around firearms, that understand situations where you might have to use self-defense. But there's always that possibility you could get a jury where people don't know much about guns, and the attorneys really have to teach the jury a lot about guns, and they have to teach them about the situations they might have to use self-defense in and not. And there's some juries that they may just always have a negative attitude against guns, so you're going in kind of with a bias against you in a trial. And it's going to vary by your community. Additionally, in Arizona, another thing to keep in mind about self-defense is that you have no duty to retreat. And this is really important. So Arizona is known as a stand your ground state. So there's many states in the United States that are stand your ground states, and then there's other states where you do have a duty to retreat. If you're here in Arizona, you can always keep in mind that you have no duty to retreat, but it's really important to keep in mind that if you do ever travel outside of the state of Arizona with a firearm, you may be in a state where there is a duty to retreat. So I always encourage people that if you do travel with a firearm, maybe research the laws of that state you're going to, because you need to know if you're in a duty to retreat state or not, because that is something that a jury will consider when they're determining whether or not you're reasonable. So in Arizona, that means if you're in a situation where someone is threatening force against you, even if you have an opportunity to safely retreat, you don't have to do it. You are able to stand your ground and use force and act in self-defense in that situation. Self-defense is also not available as a defense if you are the aggressor in a situation. That might seem kind of obvious. So if you go up to someone and you start the fight and they start to fight back with you, you can't then claim self-defense against them fighting you because you were the initial aggressor. There is an exception to that though. Let's say you are the individual that starts a fight, but maybe you're just starting a fist fight. And then the other individual escalates it and they pull out a deadly weapon against you. If they escalate it to a new level of force, that is then where you are able to use self-defense in responding to that escalation of force. Additionally, an aggressor can also claim self-defense if they tried to exit the situation. So if you were to ever start a fight and then you realized you made a mistake and you started to run away, and then the person you started a fight with started to come after you, that's another situation that even when you're the initial aggressor, you are able to use self-defense because you made an attempt to leave the fight before exercising that right to self-defense. Another important aspect of self-defense is that you may be justified in the self-defense you use against someone else, but there's always the possibility of recklessly injuring or killing an innocent third party. So this is another reason why training is so important. You need to learn when it is safe or not to exercise self-defense, because there could be a situation where you want to exercise self-defense, but you're in a really crowded area where there is that risk of hurting an innocent third party. Even though you would be justified against that aggressor in exercising self-defense, if you were to injure and kill an innocent third party, that is a situation where you could be facing charges for that action, and you would not be justified in doing so. You would not be able to exercise self-defense for that incident where you injure and kill an innocent third party. So again, those are the main things you need to know about Arizona's self-defense laws. Then there's Arizona's deadly physical force self-defense laws. We've talked a little bit about that. That deadly physical force is force that is used with the purpose of causing death or serious physical injury. This can involve a deadly weapon, but it's not always required. There can be different situations where there isn't a deadly weapon involved, but like I talked about earlier, maybe a really tall big person that would be capable of causing you a serious physical injury with just their fists. Another important thing is that deadly physical force cannot be used to protect your property. So for example, if someone came up to you and was trying to take your purse from you or your bag or just a mere piece of property, but they were being clear that they are not threatening your life, that is not a situation where you can use deadly physical force against someone. You can use ordinary physical force to protect your property, but deadly physical force to protect your property is not justified under Arizona law. There are some special privileges extended to law enforcement as well. Law enforcement is able to use deadly physical force in certain situations to, for example, catch a dangerous fleeing felon. So if there's someone that they know has committed a felony and they think they're at risk of the public and are likely to commit a dangerous felony against someone else in the course of that flight, that is a situation where a law enforcement officer is able to exercise deadly physical force. Another possible defense under Arizona law when you might use your firearm is the Arizona Crime Prevention Statute. So this is a little different than self-defense because the defense you're exercising is not that you are trying to protect yourself. The defense that you would be proving is that you are trying to prevent a crime. And Arizona has a few different crimes that you're able to exercise deadly physical force to stop. So the way the statute reads is that you can use deadly physical force to the extent a person reasonably believes, so there's that reasonableness element again, when it's immediately necessary to prevent these certain crimes. So the crimes that you're able to prevent with deadly physical force are things like arson, burglary, kidnapping, manslaughter, murder, sexual assault, armed robbery, and aggravated assault. So a lot of these are situations where you might act in self-defense or defense of others in those situations anyway. So it kind of makes sense that you'd be able to act to prevent those crimes. But there might be a time where there isn't a threat to your life or a threat to someone else's life, like in a burglary, where you might want to exercise deadly physical force. And the important thing about this is that you don't actually have to wait for someone to start committing the crime. So you don't have to wait for someone to cross into your house to actually use deadly physical force to stop a burglary. You have to have a reasonable belief that they are there to commit a burglary there. So if you see, for example, someone that is paid to come into your house as a maid, and you know them, you know they're your maid, you know they have a key to your house, and you see them coming into your house, that's a situation where it wouldn't be reasonable to think that the maid is there to come commit a burglary, and you wouldn't be able to use a deadly physical force to stop them from entering your home. However, there would be situations where you could see someone, maybe if they have a burglary tool with them, you can see them messing with a handle to get into your house. That's a situation where you'd be able to use deadly physical force, not necessarily in defense of your life or defense of someone else's life, but to prevent that crime of burglary. So I like to share the crime prevention statute because that's another situation where you can use to exercise deadly physical force. But anytime you exercise deadly physical force, there is going to be a risk to you to do so. So it's always good to think ahead and think of the certain types of situations where you would be prepared to exercise either ordinary physical force or deadly physical force. So that way, when you're in that stressful situation where something comes up, where there's a threat to your life, a threat to someone else's life, a threat to your property, or a threat of a crime being committed, you already have an idea of how you might choose to react. Because different people might make different decisions. And the important thing is to have all the information in front of you. Anytime you exercise deadly physical force, anytime you discharge a firearm, no matter if it was a perfect shoot, no matter if you're perfectly justified in self-defense, there is still that risk that someone is going to misinterpret what happens. And I can say that from experience that I have seen people, really responsible gun owners, exercise the perfect case of self-defense and still get taken into custody. And it's unfortunate, but you can kind of see how that can happen. An example I like to give is imagine you are walking down the street. And about 30 feet behind you, there was another person walking behind you. All they can see is your back. In the other direction, someone is walking towards you. That person, really close to their chest, pulls out a gun and points it at you and says, "I'm going to shoot." So all the person 30 feet behind you can see is that you're facing a person. All they can see is your back. They can't see that other person. They can't see the fact that they're holding a gun. However, they can see you pull out your gun in response and shoot that person. And again, that would be the perfect case of self-defense. Because in that situation, you're facing deadly physical force. That person has pulled out a gun. They are pointing at you. They've said they're going to shoot right now. It's an imminent threat. It would be reasonable to act in self-defense in that situation. However, all the witness sees is he sees you pulling out your gun and shooting that person. He doesn't see the other person's gun. And maybe when you shoot that person, the gun falls out of you. The person never sees the other gun. They call 911, they report you, and then suddenly you're getting arrested. And this is a situation where a lawyer could step in, prove the fact that the other person had a gun, but that's not going to stop the fact that for at least for a while, you could be in custody. That could be a situation where you're facing a high bond to get out. It's a situation where you're going to need a lawyer. It's a situation where you're facing charges. It's going to be a very stressful situation to deal with. And you have to keep in mind how you're going to react in that situation. You have to keep in mind anytime that you use deadly physical force that there is that risk of going into custody. And again, I like to repeat this. This is not me trying to discourage you from exercising self-defense in a situation where you need to protect your life, but it is me trying to encourage you to be prepared for these situations and be prepared for what might happen after you act in self-defense. You know, as a criminal defense attorney, I love criminal defense. It's fun for me to work on these types of cases, but that's not the only reason I do it. As a criminal defense attorney, I do like to make money, but that's not the only reason I do it. I don't do it for the money. I don't do it just because they're fun. I do it because our Second Amendment rights are so important. And there are many people in this country that try to push against our Second Amendment rights, that try to limit our Second Amendment rights. And we have responsible gun owners out there that are in situations where they need to be able to have that right to self-defense available to them. And I want to be able to fight for those individuals that chose to protect their own lives, chose to carry a firearm so they could have that option to protect their lives or to protect the lives of their loved ones. And this is why I love Attorneys on Retainer, because it just helps us do that. So if you have any questions about Attorneys on Retainer, feel free to ask me about this after. We also have a booth in there as well. But it's just something to think about. So I always like to tell people, you need to think about when you might choose to use deadly physical force or ordinary physical force. So there's a few situations I always like to go over. They're pretty simple scenarios, and I think you can kind of think through when you might use force in those situations. But again, you don't want to be thinking about these things for the very first time when you're in that stressful situation. If you're facing a threat to your life, you kind of want to think about these things ahead of time. So the first question I always ask is, would I pull out a firearm if I am faced with a threat to my life? I think that's a pretty easy yes. Yes, if I'm facing a threat to my life, I'm going to pull out my firearm and act in self-defense, knowing that the possible risk of acting in self-defense, even if it is perfect self-defense, if it's misinterpreted, there's always that risk in prison. So I'm pulling out a firearm to protect my life because I would rather be alive even if I'm in prison. The second situation I always like to contemplate is, would I pull out my firearm if someone I love is facing a threat to their life? Again, that's an easy, absolute yes, I would do so. If someone I love is facing a threat to their life, of course I am pulling out a firearm to defend them, because it is worth it to me that even if that risk, that it's misinterpreted and go to prison, I would much rather go to prison than someone I love die. The third situation I think about is, would I pull out a firearm to defend myself if I'm facing a punch to the face? This one might be a little controversial for some people, but no, I'm not pulling out a firearm in that situation. The reason I say no is because I know the possible risk in any situation of pulling out a firearm is going to prison. And I'd much rather be punched in the face than go to prison. However, there's a situation if I'm maybe facing a punch to the face from a 6'5", 300-pound man where I know that punch could possibly really seriously injure or kill me, that's a situation I might pull out a firearm. However, if it's a 13-year-old girl that's never lifted a weight in her life, that's a situation where I'm taking the punch to the face because I'd rather take the punch to the face than potentially end up in prison. The fourth scenario I always consider is, would I pull out my firearm if someone has insulted me? Absolutely not. That's an easy one. We're not pulling out our firearm in that situation because verbal provocation is never a justification under Arizona law for pulling out a firearm. If you are verbally provoked, verbally insulted, unless it's a direct threat to your life and there's an action supporting the fact that it's a direct threat to your life, verbal provocation is never enough to pull out a firearm in Arizona. If someone insults you and you respond with deadly physical force, that is a guaranteed ticket to prison. So I always encourage you to kind of start thinking about these situations now. Think about those 4 scenarios when you might choose to use deadly physical force. And you can get a little more specific with it because there's self-defense situations, there's defense of others situations, and I know some people might choose to exercise defense of others for a family member or to protect a friend, but maybe they might not choose to do so for a stranger. I know some of us might act in defense of others for a stranger, but some of us might not because we know that there is that risk of going to prison. So the things to think through of what could happen after using deadly physical force: maybe you have a bad shoot, maybe you made a mistake of fact, maybe you thought you were facing a serious risk of physical injury or death and you got something wrong. Maybe you thought it was a real gun, but someone was actually shooting a Nerf gun and you got confused. Another thing to keep in mind is that Arizona has a mistake of fact provision under the law. Mistake of fact basically protects you that if you got a detail wrong when acting in self-defense, if it was reasonable for you to make that mistake of fact, then you can still assert self-defense and use that as a justification for your self-defense. So there is that protection under Arizona law, but again, that key word is going to be reasonable, because there are certainly things that are reasonable mistake of facts, and then there are things that are unreasonable mistake of facts. However, when you use deadly physical force, the things that could happen include being arrested, going to jail, a high bond being set, potentially being charged with a crime. Something to know about Arizona law is many of these crimes are going to have what's called a mandatory minimum. So that means that if you are charged with a crime for your use of self-defense or defense of others, something like an aggravated assault, something like a murder, these charges carry mandatory minimums under the law. So if you choose to exercise your right to go to trial, that means if you were to lose at trial, there is a mandatory penalty that they would have to give you for prison. So there's always a range that a judge can consider, but there's basically a minimum that they have to give. So for example, if you were to go to trial on an aggravated assault and you were to lose at that trial, the minimum a judge would have to give you, even if they didn't want to, would be 5 years in prison. And they could give you up to 15 years in prison for that aggravated assault. So that's something to keep in mind, that if you do exercise a right to go to trial in the case, there's a minimum that the judge is going to have to get you. So that's a reason why many people choose to take plea deals in cases, and even in cases where they know they're innocent, because they may not want to take that risk of facing that mandatory minimum at trial. So that's another reason why you just want to be prepared for these situations, knowing that anytime you exercise that use of deadly physical force, there is that possibility that you could be charged, could be arrested, could be convicted, and could be facing a mandatory minimum. If you are convicted of a crime like aggravated assault or murder in Arizona involving a firearm, it's going to be a long and stressful experience. You're going to end up with a felony on your record. And not just a felony on your record, but you're going to lose some rights along with it. In Arizona, if you're convicted of a felony, you lose your right to vote. You lose your right to a firearm. And often in firearm-related offenses, you lose your right to own a firearm permanently. So these are pretty serious consequences you could be facing. Depending on the charge that you're facing, you may be able to get that right to possess a firearm restored, but there's no guarantee that that could happen. So these are all potential penalties that could arise from a self-defense scenario. So you have to ask yourself, when you choose to use self-defense, are these potential penalties better than what would have otherwise happened. Because there are certainly situations where I will say, yes, even if I get this most severe penalty, it's better than what would have otherwise happened. I would rather get this most severe penalty of going to prison and losing my firearm rights than ending up dead, or someone I love ending up dead. But there are some situations I can contemplate, like the situation I described earlier. Getting punched in the face, no. Losing my firearm right permanently is not better than getting punched in the face. So you have to think through these things ahead of time. Another thing to consider under Arizona law is that you also have the right to a defensive display of a firearm. Again, so a defensive display is a little different than exercising self-defense, defense of others, or a crime prevention. Defensive display is a situation where you might tell someone else you have a firearm. It might be where you expose or display a firearm in a protective manner. So if I was to have a firearm under here and I was to lift my coat, that could be considered a defensive display of a firearm. Placing your hand on a contained firearm, so if you have one holstered, and gesturing and placing your hand on that firearm. Those are all things that are considered defensive displays, and these are all things that are justified under Arizona law. So that is also an option. But this is one of the reasons why I always encourage people to consider both the perspectives of a legal expert as well as a tactical expert. I think training is so important. And there's going to be times where maybe an attorney like me might tell you something a little differently than what a tactical expert might consider. And it's important to consider both of these things. For an example, a lot of people will ask me, hey, what should I do after I use my firearm in self-defense and the person I shot is in need of medical attention? They'll ask me, should I give medical attention to that person or should I not? And from my experience as a criminal defense attorney, I can tell you anytime someone has helped and provided medical care to someone that they've shot, it actually really helps negotiate the case. Prosecutors do like to see that. However, whenever I say that, I can see many tactical experts will cringe, because I think it's not surprising to hear the fact that if you exercise medical attention to someone you just shot, you are putting yourself in severe risk. Because if that person was threatening deadly physical force against you, just because you shot them, just because you temporarily neutralized the threat, doesn't necessarily mean the threat is over. Maybe you shot them, but it wasn't a deadly shot. Maybe they're still going to try to get back at you and hurt you. Maybe they're on the ground for now, but they might rise up and attack you after the fact. So when you ask a criminal defense attorney, should I provide medical care to the person I just shot, I have to say from my experience, yes, it actually does help me negotiate a case. It's something the prosecutors will look at and see, oh, well, if they helped and gave medical care, it probably means they didn't actually really want to hurt and kill someone. However, a tactical expert might tell you, you're putting your life in extreme danger to go and help that person you just shot. So it's good to hear both perspectives, because it's really, at the end of the day, there's a lot of personal responsibility, as I'm sure we all know, to carrying a firearm. And a lot of this will come down to what you're comfortable with and what kind of risk you want to take. So in those situations, again, an attorney might say one thing, a tactical expert might say another. So it's good to consider both sides and good to consider where you personally, as a gun owner, want to place your risk. The next thing I wanted to talk about is what to do in that emergency once it arises. So let's say you are in a situation where you have exercised deadly physical force, or even ordinary physical force, and you're concerned that you may be charged with a crime. The first thing you should do is, if there is a human life in danger, including your own, you should always start by calling 911. The 911 call is important, though, because you don't want to be saying anything on the 911 call that could potentially incriminate you. So you need to be careful with what you say. Usually we encourage you to say something very simple, just saying the location of what happened and saying something very vague like there was a shooting, just so you can get police, just so you can get medical to the scene. And I know it might be hard. They might push you for more information. They might ask you more questions. You got to refrain, because even something that might seem innocuous, that doesn't seem like a big deal to say in the moment, could be something that could incriminate you later on. The way we put it is just shut up. That's what we always say. I think the two most important pieces of advice that almost apply in every situation following a shooting is don't get shot and just shut up. We always tell people that when police might respond to the scene, they may not know if you're carrying a firearm. They might not know if you were the aggressor or not. They may think potentially if they see you carrying a firearm that you were the aggressor. So if there's a situation where police are responding to the scene and the threat against you has been neutralized, you probably don't want to be holding that firearm or pointing that firearm when the police arrive at the scene. So you'll want to safely secure that firearm by the time police arrive. However, I do recognize there may be some situations where you've called police, but you're not sure if the threat has been neutralized. If it is a situation like that where you may still need to keep your firearm available, it's a situation where you want to be ready to respond once the police get there. That you're ready to put your hands up, set down the firearm when the police come, put your hands up, and be ready to respond to everything the police say. When the police get to the scene, they may choose to arrest you. Even if you were acting in self-defense, they may not know what had happened. Maybe they think you were the aggressor. Maybe they think it was a bad case of self-defense. Maybe they thought it was a bad shoot and you exercised self-defense when you really weren't justified in doing so. If they proceed with choosing to arrest you in that situation, you need to comply. You need to follow the police's lawful order. There's always a chance to challenge an unlawful arrest after the fact. So at that time, you comply. Again, the police are probably going to be pressing you for questions at this point. So again, the same advice when talking to a 911 operator of just shut up applies here as well. If police are trying to ask you questions after a self-defense shooting, just shut up. I know it's hard. I know police will sometimes say things like, hey, I'm on your side. I'm just trying to help you out. And you know, these police officers, they're trying to do their job in this situation. These are good guys trying to do their job. But you have to recognize as part of their job, they may potentially see you as the bad guy in the situation. So you need to be prepared for the fact police are allowed to lie to you. They may say something like, hey, we have video footage of the incident and we can see you shooting. Even if there is no video footage, police are legally allowed to lie to you in these situations. They may make it feel like it's a situation where it is comfortable to talk. Again, you need to just shut up until you have a chance to talk to a lawyer. So you may get a reminder from police. They may read you your Miranda rights, tell you that you have the right to remain silent, the right to ask for a lawyer. In that situation, you should assert that right to remain silent and ask for a lawyer. Because remember that silence can't be used against you in court. Silence is not a reason that an officer is justified in arresting you. And just remember that any statement you make can limit the legal theories we make in a case. Let's say police respond to a scene and you say, I was in fear for my life. That's advice that some attorneys and some self-defense experts do encourage people to say. Some attorneys will say, if police respond to the scene after a self-defense shooting, say, I was in fear for my life. And that's something that seems like, hey, that statement probably can't be used against me. But what if the police didn't even know who the shooter was? Suddenly you've identified yourself as the shooter by saying, I did this because I was in fear for my life. So even a statement like that sounds like it should help you could be used against you in a criminal case. So statements like this could limit our legal theory because, for example, our legal theory could be the state can't prove that you were the shooter. If you say, I shot him because I was in fear for your life, you've suddenly just limited the legal theory I could use in your case. Another reason why you don't want to make statements at that situation is because you're likely going to be under a lot of stress. When you're under stress, you may not say things you mean. You may not say the smartest things. I know when I'm under stress, I will say some things that sound a little bit stupider than when I'm just at peace. So again, it's probably not the time to make statements. Also, your statements may not be recorded correctly. So if you remain silent, there's no risk of your statement being written down in a police report wrong. They'll say he remained silent. But if you make statements, it's possible the officer might record your statement incorrectly. And now suddenly the only statement you said on the record is something you actually didn't say at all. But there are a few exceptions of when you will need to make a statement and when you do have to talk to officers. The first exception is, like I said earlier, when you might need to call 911. If there is a threat to your life, to another human life, and you call 911, again, you keep it vague. You say only the information you need to get police to come to the scene. Something very vague, like there was a shooting, this is the address, then you hang up. Another exception for when you might make a statement is after a consultation. There are some rare situations where people come in and talk to me and say, hey, I was in a self-defense incident, and we determined that it is safe to make a statement. Most of the time, that is not the case. But in those few times where making a statement is the most strategic move in a case, a lawyer can help you make that decision. You just don't want to make a statement that could ruin your case before that point. You want to talk to a lawyer, talk about what would be okay to say. Another exception is that if a police officer comes to you and asks you to truthfully identify yourself, you are required to truthfully identify yourself to a police officer. So you are required to give a truthful name to an officer if they ask. But you don't have to say anything else. You don't have to add any additional information after identifying yourself truthfully to an officer. Another exception is if you are in a traffic stop and an officer asks if you are carrying a concealed weapon. This is another exception under the law. There is a misconduct involving weapons misdemeanor charge for failing to truthfully answer if you're carrying a concealed weapon. So you do have to truthfully answer, but those are the only pieces of information you have to reveal to an officer under the law. If you're carrying a concealed weapon, if they ask you, and to truthfully identify yourself. But otherwise, all other things, you absolutely should remain silent until you've had the chance to talk to an attorney. So again, with attorneys on retainer, these are all things that we love to help our clients with. Attorneys for Freedom, our law firm, we also love to help people through these situations. There are many things that Attorneys on Retainer helps with. If you missed this at the beginning, Attorneys on Retainer is a self-defense protection program. We have 3 criteria for coverage. The first is that an incident arises after you're a member of Attorneys on Retainer. The second criteria for coverage is that you're charged with a crime or reasonably expect to be charged with a crime. And then the third is that you can assert self-defense or defense of others as a defense to that crime. If you meet these 3 criteria for coverage and you're a member of our program, then we are able to fully cover your legal fees for a self-defense incident. So all of your attorney's fees, we pay for the experts, we pay for investigators, we pay for mental health counseling, firearm replacement, scene cleanup. We'll help you post your bond. If there's a civil defense case attached to it as well, we'll help you in the civil case. We'll also help if, let's say, we get the charges against you dropped and you want to maybe get some money back from the aggressor, we could represent you as a victim as well. So there's a lot that goes into the Attorneys on Retainer program. But overall, the main takeaways today is that a responsible gun owner should be familiar with self-defense laws. They should have considered when to use self-defense or defense of others and know what to do after an emergency. So I have a few more minutes here today. Does anyone have any questions just about self-defense law, defense of others, anything related to Attorneys for Freedom, Attorneys on Retainer? I see a question over here. He asked, what would be the perfect case of self-defense where police, after responding, wouldn't really even need a big investigation? It's really obvious to them. There's not many of those. I'll tell you that first of all. The truthful answer is there, in most situations where deadly physical force have been exercised, the police do some type of thorough investigation. Even if they recognize that you're not the aggressor right away, they might take a little bit of time to formally make that decision. Usually times where we see a very cut and dry case, though, where it's much easier for officers to come to that conclusion, is a situation where there were numerous witnesses or a very clear video of what happened. A lot of times where people run into trouble is where there's a bad angle on a video, or maybe there was only one witness that was not at a favorable angle for your case of self-defense. But usually the ones where it's really cut and dry is a situation where you're facing deadly physical force, the person pulls out their gun, they're clearly pointing at you, they're threatening you, making it clear they're preparing to use the gun. You respond with your own deadly physical force, and then there's a number of witnesses or a clear video to kind of corroborate your story. Without some of those things, we see these cases like I'm talking about where even if you have a good case of self-defense, Maybe the angle makes it look bad. The angle of the video camera that captured the incident makes it look bad. Or maybe the eyewitness only saw part of what happened. Or maybe there were no witnesses at all. And you have to tell the officers, or after talking to an attorney, explain to officers the fact that you were not the aggressor, the other person was the aggressor. So that was a great question. Are there any other questions here about self-defense law, defense of others, attorneys for freedom, attorneys on retainer? We have one up here. Okay, so we have a couple questions here. The first one I wanted to address is we had a question about red flag laws. So red flag laws are something we're seeing across the country, and you're absolutely right. Arizona currently doesn't have a red flag law, but a red flag law is basically a mechanism for someone to go in front of a judge and tell someone that because of some mental health reason, they think another person is not able to be safe with a firearm, not able to safely possess a firearm or carry a firearm, and a judge is able to make a determination that they can take away that person's firearm because of that mental health concern. We're seeing a lot of states across the United States starting to try to implement these red flag laws, and it's really a threat to our Second Amendment rights because it really is taking a very low burden of proof that judges have to meet in order to take away someone's gun rights. So it's often these orders are temporary. So if someone is found to be impacted by a red flag law, usually their guns are taken away for like a year or two. That's the most common length that a red flag law applies. But currently in Arizona, luckily we don't have them. But it is something that many states across the country are trying to add. So every year I follow every different state and kind of look into what kind of firearm bills are being passed. Every year, many states are trying to pass red flag laws, and unfortunately, more and more states have been successful over the past few years, and it's kind of scary to see because these laws have such a low standard, and it's really hard for people to challenge these red flag rulings. So he was talking about in a criminal, it sounds like if you're charged with a crime and the criminal case was dismissed related to a self-defense incident, and then you're also facing a civil action related to that case of self-defense, you can present evidence in that civil case. There are certain documents you can present, but it doesn't guarantee a result in the civil case. So you can get a copy of your dismissal, and there's a few different things you can get. So you can get a copy of a dismissal order. That will definitely help you in a civil case, but it doesn't necessarily guarantee that the civil case is going to be dropped. So even if you win a criminal case for a self-defense incident, you can still be successfully sued in a civil case. It's just unlikely if there is something like a dismissal order. But something that would be a little bit more convincing is after you get a dismissal order in a case, you can then apply to the court to get your record cleared. And that might be what they're talking about, because once you get your record cleared, it's a little bit more than a dismissal. Because dismissals don't necessarily mean you're innocent, it just means that there wasn't enough proof to convict you. Or the prosecutor didn't think there was enough proof, the judge didn't think there's enough proof. Because you have to meet that beyond a reasonable doubt standard to get convicted of a criminal offense. So sometimes when a case is dismissed against you, it's not necessarily the court saying, we believe you're innocent. They're saying, you may be innocent, you may not be. There's just not enough evidence here to convict you. However, if you do this next step and petition the court to clear your record, that is something where the court is finding innocence there. So if you get that determination made in a case and present that in a civil case, that is something that is even more likely to help you win a civil case because it shows that your record's been cleared, that the court considers you innocent. I have to wrap up here today, but I will be standing over here. So if you have any other questions that you want to ask me just one-on-one, I'll be available. We also have some people inside that can tell you a little bit more about Attorneys for Freedom and Attorneys on Retainer. I appreciate you all coming out today. Thank you.